count 9 will be conspiracy to commit aggravated murder. That will be in violation of sections 2923-01A1, A2, section 2923-01J1, and a felony in the first degree. You're pleading guilty to count number 10, aggravated burglary, a violation of section 2911A1 and A2, and sections 2911-11B, a felony in the first degree, and guilty to specification 1-year firearm specification in violation of section 2941-141. A guilty plea to specification 2, 3-year firearm specification in violation of section 2941.145, and specification 3 was having a suppressed firearm, 6-year specification in violation of section 2941.144. Count 11, aggravated burglary in 2911-11A1, A2, 11B of the higher revised code, felony in the first degree, being guilty to specification 1 in a violation of section 2941-141, 1-year firearm specification, guilty to specification 2, 3-year firearm specification in violation of section 2941.145, and guilty to specification 3 in a suppressed firearm, 6-year specification in violation of section 2941.144, and guilty to count 12, aggravated burglary, violation of section 2911-11A1, A2, 11 and 11B, in a felony in the first degree, guilty to the first specification 1, 1-year firearm specification 2941.141, guilty to specification 2, 3-year firearm spec 2941.145, guilty to specification 3, in suppressed firearm, 6-year specification, violation of section 2941.144, and guilty to count 13, aggravated burglary, a violation of section 2911-11A1, A2, 11B, and a felony in the first degree, and guilty to specification 1, violation of section 2941-141, 1-year firearm specification, guilty to specification 2, 3-year firearm specification in violation of section 2941-145, guilty to specification 3, suppressed firearm in violation of section 2941-144, 6-year firearm specification, guilty to count 14, unlawful possession of dangerous ordnance, a violation of section 2923-17A1 and 2923-17B, being a felony in the 5th degree. Guilty to count 15, tampering with evidence, a violation of section 2921-12A1 and 12B, a felony of the 3rd degree. Count number 16, tampering with evidence, a violation of section 2921-12A2 and 12B, a felony of the 3rd degree. Guilty to count 17, tampering with evidence, a violation of section 2921-12A1 and 12B of the higher revised code, and a felony of the 3rd degree. Guilty to count 18, forgery, a violation of section 2913-31A1, A2, C1B, which is a violation of a revised code, and a felony of the 5th degree. Guilty to count 19, unauthorized use of property, a violation of section 2913-04B and G2 of the higher revised code, and a felony of the 5th degree. Guilty to count 20, interception of wire, oral, or electronic communications, a violation of section .52A1 and 52C, a felony of the 4th degree. Guilty to count 21, obstructing justice, a violation of section 292132A4, A5, and C3, a felony of the 5th degree. And guilty to count 22, engaging in a pattern of corrupt activity, a violation of section 292332A1, and 32B1, a felony of the 1st degree. And guilty to the first specification 1, involving a 1-year firearm specification, a violation of section 2941.141. Guilty to specification 2, a 3-year firearm spec, in violation of section 2941.145. And guilty to specification 3, involving a suppressed firearm, in violation of section 2941.144, a 6-year firearm specification. And in exchange for the guilty pleas to both charges, the state would move to dismiss counts 1 through 8 of the indictment and specifications 1 and 2 from count 14 of the indictment. And additionally, Your Honor, we have executed the state and the defendant a defendant's agreement, which will be filed under seal at the conclusion of this hearing, and that defendant's agreement will be incorporated into this plea agreement. The highlights of that, Your Honor, would be the state agrees to dismiss the aggravated murder charges in count 1 through 8, as I just mentioned. The defendant and the state will make a joint recommendation to this court that the defendant receive a total of 30 years in prison for the above charges which he will be entering plea to guilty. And pursuant to this agreement, our agreement and recommendation is based solely and strictly upon the defendant's fulfilling her agreement to testify truthfully in each and every of the other defendants' co-defendants' trials, and also based on our understanding that she will serve the entire 30-year prison sentence with no reduction based on judicial release, risk reduction release, earned days of credit, transitional control, or any other provisions that currently exist in Chapter 2967 or other parts of the higher by schedule, or anything that would appear in the future which might result in a sentence reduction or early release, including an agreement by the defendant she will not seek clemency for any of the charges for which she's pleading guilty. This would apply to both mandatory and non-mandatory portions of her sentence. Again, what I've stated on the record, with the addition of our defendant's agreement to be filed under seal, is the sum total of our plea agreement in this case, Your Honor.
Thank you. Mr. President, with Mr. Hunt, does that sound like the agreement reached between the defense and the state of Ohio?
It is, Your Honor.
Ms. Wagner, does that sound like the agreement that you reached with the state of Ohio?
Yes, Your Honor.
Before giving you an opportunity to change your plea, before considering changing your plea, the court needs to go over several things with you here on the record. I want to make sure that you do understand everything, and I also want to determine whether, in fact, you want to waive the rights that you will be waiving if you change your plea to a plea of guilty to the charges and specifications that you just mentioned by the prosecutor. The first question which the court will ask of you now, which we ask of everyone changing the plea in court here, is whether right now you're under the influence of alcohol or any controlled substance or anything else that might adversely affect your ability to understand what's going on here today.
No.
Have you ever been adjudicated by any court to be mentally incompetent?
No.
Do you feel that you do understand everything that's going on?
Yes, Your Honor, I do.
All right, the record should reflect that the defendant does appear to be alert, does appear to be understanding the nature of the proceedings and what's going on here today. You were charged in this case with several counts and several specifications, and the court will go over those here on the record. Count 9 of this indictment charges that Angela Jo Wagner, on or about the first day of January 2016 through the 12th day of November 2018, at the County of Pike, or by some manner enumerated in section 2901.12 of the Ohio Revised Code, whereby the proper venue was placed in the County of Pike in the state of Ohio, did unlawfully and with purpose to commit or to promote or facilitate the commission of aggravated murder, and/or aggravated burglary with another person or persons to it, Edward Jacob Wagner and/or George Washington Wagner II and/or George Washington Wagner IV, and/or any other unidentified and/or unknown individuals plan or aid plan the commission of any of the said aggravated murders, and/or aggravated burglaries, and/or agree with another person or persons to wit, Edward Jacob Wagner and/or George Washington Wagner III and/or George Washington Wagner IV, and/or any other unidentified and/or unknown individuals, that one or more of them would engage in conduct that facilitates the commission of any of the said aggravated murders, and/or aggravated burglaries, and subsequent to said Angela Jo Wagner's entrance into the conspiracy, a substantial overt act or acts in furtherance of the conspiracy was committed by the said Angela Jo Wagner or a person with whom the said Angela Jo Wagner conspired, including but not limited to the following overt acts to wit: making several purchases in the months leading up to the said aggravated murders, and/or aggravated burglaries, including but not limited to the following items: specific shoes from Walmart, grass catchers, items with which to build grass catchers, ammunition, a magazine clip, a bug detector, and/or parts to build a silencer, and/or various other items in preparation of these crimes, building a silencer or silencers, forging documents, including forged custody documents, obtaining and sharing information regarding the victims and their properties in preparation for these crimes, to include their habits and routines, sleeping locations, physical layout of properties, surveillance devices present on the properties, including pets, illegal monitoring of various social media accounts, destroying and/or tampering with evidence of the crimes, including but not limited to a video recording device which Edward Jacob Wagner had purchased in March of 2016, a silencer, video and trail cameras belonging to the victims, and/or phones belonging to some of the victims, moving the body of Christopher Rhoden Sr. and/or the body of Gary Rhoden, providing false and/or misleading information to the authorities, and/or various other known and unknown overt acts, and/or one of the objects of the conspiracy was aggravated murder, or the offense for which the maximum penalty is imprisonment for life in violation of section 2923.01A1 and/or A2 and 2923.01J1. That states conspiracy and is a felony of the first degree. A felony of the first degree is punishable if you're convicted of plead guilty by a possible prison term and/or fine. The basic prison terms are 3, 4, 5, 6, 7, 8, 9, 10, or 11 years. The maximum fine is $20,000. And typically, the court would order a defendant who's convicted or pleads guilty to pay the court cost and, if applicable, pay restitution. And upon your serving any prison term imposed by the court in full, the law also requires for a first-degree felony that you be released from prison for 5 years under mandatory post-release control, during which your conduct will be supervised by the adult parole authority. Count 10 charges you with aggravated burglary and reads: Angela Jo Wagner, on or about the 22nd day of April 2016 at the county of Pike County in the state of Ohio, did unlawfully by force, stealth, or deception trespass in an occupied structure, to wit, camper located at 1084 Left Fork Road, Raritan, Ohio, when another person other than an accomplice of said Angela Jo Wagner was present, with purpose to commit in the structure any criminal offense, and said Angela Jo Wagner inflicted physical harm to another, to wit, Kenneth Rhoden, and/or the said Angela Jo Wagner had a deadly weapon or dangerous ordinance on or about the said Angela Jo Wagner's person in violation of section 2911.11A1 and/or A2 and 2911.11B of the Ohio Revised Code. That states aggravated burglary and is a felony of the first degree. Again, punishable, as I indicated, with respect to count 9, by a prison term and/or fine, 3, 4, 5, 6, 7, 8, 9, 10, or 11 years. Our basic prison terms, $20,000 is the maximum fine. For typically also for the cost of restitution. And when you're serving in the prison term imposed by the court, requirement that you be released from prison imposed police control for a mandatory period of 5 years. There are 3 specifications with respect to count 10. Specification 1 to the 10th count states that the grand jurors further find to specify that the said Angela Jo Wagner had a firearm on or about her person or under her control while committing the said aggravated burglary, as specified in section 2941.141 of the Ohio Revised Code. That if you are found guilty of that specification, then in addition to any prison term that may be imposed for the underlying felony, the court would be required to impose a 1-year mandatory prison term that would be served consecutive to and prior to any prison term imposed for the underlying felony offense. Specification 2 to the 10th count states that the grand jurors further find to specify that the said Angela Jo Wagner had a firearm on or about her person or under her control while committing the said aggravated burglary, and displayed the firearm, brandished the firearm, indicating that the said Angela Jo Wagner possessed the firearm and or used it to facilitate the said aggravated burglary, as specified in section 2941.145 of the Ohio Revised Code. That states a firearm specification that would require the court, if you are found guilty of that specification, then in addition to any prison term imposed on count 10, the court would be required to impose a 3-year mandatory prison term for the specification 2, and that would have to be served consecutive to and prior to any prison term imposed on count 10, the underlying felony. Specification 3 to the 10th count states the grand jurors further find and specify that the said Angela Jo Wagner had a firearm that is an automatic firearm or that was equipped with a firearm muzzle or suppressor on or about her person or under her control while committing the said aggravated burglary, as specified in section 2941.144 of the Ohio Revised Code. If you are found guilty of that specification and in count 10 and also found guilty of count 10, in addition to any prison term imposed for the underlying felony, the court will be required to impose a 6-year mandatory prison term for the specification 3, and that prison term will be served consecutively to and prior to any prison term imposed for the underlying felony. Now, count 11 also charges you with a second count of aggravated burglary, and reads as follows. Angela Jo Wagner, on or about the 22nd day of April 2016 in the county of Pike County in the state of Ohio, did unlawfully by force, stealth, or deception trespass in an occupied structure, to wit, 4199 Union Hill Road, Pike, Ohio, when another person other than an accomplice of the said Angela Jo Wagner was present with purpose to commit in the structure any criminal offense, and the said Angela Jo Wagner inflicted physical harm on another, to wit, Clarence Frankie Rhoden and or Hanna Hazel Gilley, and or the said Angela Jo Wagner had a deadly weapon or dangerous ordinance on or about the said Angela Jo Wagner's person in violation of section 2911.11A1 and or A2 and 2911.11B of the Ohio Revised Code. That states aggravated burglary, and on account of that, a first-degree felony, possible prison terms for which are 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, $20,000 maximum fine. The court would typically order court costs and restitution if applicable, and also upon your serving any prison term imposed in count 11, the requirement of law is that you be released from prison on post-release control for a mandatory period of 5 years. Count 11 also has 3 specifications to it. These 3 specifications stated with respect to count 11 are identical to those stated with respect to count 10, and the effect is the same if you are found guilty of any one or more of these specifications. The effect is the same as that mentioned with respect to count 10. A mandatory 1-year prison term on count 1 would be on specification 1 to the 11th count would be required if you're found guilty of that specification. A 3-year mandatory prison term would be required with respect to specification 2 on the the 11th count, and a 6-year mandatory prison term would be required with respect to specification 3 to the 11th count. Each of those prison terms would be required to be served consecutively to and prior to any prison term imposed with the underlying felony charge for the count 11. Count 12 charges you with a third count of aggravated burglary and reads as follows. Angela Jo Wagner, on or about the 22nd day of April, 2016, at the county of Pike and in the state of Ohio, did unlawfully by force, stealth, or deception trespass in an occupied structure, to wit 4077 Union Hill Road, Piketon, Ohio, when another person other than an accomplice of the said Angela Jo Wagner was present with the purpose to commit in the structure any criminal offense. And said Angela Jo Wagner inflicted physical harm on another, to wit Christopher Rhoden Sr. and or Gary Rhoden, and or the said Angela Jo Wagner had a deadly weapon or dangerous ordinance on or about the said Angela Jo Wagner's person in violation of section 2911.11A1 and or A2 and 2911.11B of the Revised Code. That states aggravated burglary, a felony in the first degree. Again, if you're convicted of that, you can serve a prison term and will pay a fine. The basic prison terms are 3, 4, 5, 6, 7, 8, 9, 10, 11 years, the maximum fine $20,000, and the court will typically order court costs and restitution if applicable. And when you're serving any prison term imposed on count 12, the requirement of law is that you be released from prison on post-release control for a mandatory period of 5 years. There are also 3 specifications to count 12. Those are identical to the 3 specifications to counts 10 and 11. Specification 1 to the 12th count would require, if we're convicted of the count 12 and are found guilty of that specification 1, the court will be required to impose a 1-year mandatory prison term to be served prior to the consecutive with any prison term imposed on count 12. Specification 2, if you're found guilty of specification 2, then in addition, any prison term imposed on count for aggravated burglary on count 12, the court will be required to impose a 3-year mandatory prison term for the specification 2, that to be served prior to consecutively to any prison term imposed with the underlying felony. And specification 3, if you're found guilty of that, as well as guilty of count 12, the court will be required to impose a 6-year mandatory prison term to be served prior to consecutively to any prison term imposed with the underlying felony charges in count 12. Count 13 charges you with a 4th count of aggravated burglary and states that Angela Jo Wagner, on or about the 22nd day of April 2016, in the county of Pike and in the state of Ohio, did unlawfully by force, stealth, or deception trespass in an occupied structure, to wit 3122 Union Hill Road, Piketon, Ohio, when another person other than an accomplice of the said Angela Jo Wagner was present with the purpose to commit in the structure any criminal offense. And said Angela Jo Wagner inflicted physical harm on another, to wit Dana Rhoden, Hanna May Rhoden, and or Christopher Rhoden Jr., and or the said Angela Jo Wagner had a deadly weapon or dangerous ordinance on or about the said Angela Jo Wagner's person in violation of section 2911.11A1 and or A2 and section 2911.11B of the Revised Code. That is a first-degree felony entitled aggravated burglary. If found guilty of that, the court can impose a prison term. Basic prison terms are 3, 4, 5, 6, 7, 8, 9, 10 years. The court could also, in addition to that, or as an alternative to that, impose a fine not to exceed $20,000. The court typically will report loss of restitution. Also, if applicable. Also, the law requires, upon your serving the prison term imposed for the first-degree felony charge of count 13, you can release from prison for post-release control for a mandatory period of 5 years. Specification 1 to the 13th count, specification 2 to the 13th count, and specification 3 to the 13th count are identical to specifications 1, 2, and 3 charged with respect to count 10, 11, and 12. And if you you are found guilty of specification 1, the court again will be required to impose a 1-year mandatory prison term. And if it's found guilty of specification 2, the 13th count, the court would be required to impose a 3-year mandatory prison term. And if it's found guilty of specification 3, the 13th count, the court would be required to impose a 6-year mandatory prison term. Those prison terms would be required to be served consecutively to and prior to any prison term imposed for the underlying felony charge in count 13. Count 14 charges you with unlawful possession of dangerous ordnance and states that Angela Jo Wagner, on or about the first day of January 2016 through April 22nd, 2016, in the county of Pike and the state of Ohio, did unlawfully and knowingly acquire, have, carry, or use any dangerous ordinance in violation of section 2923.17A1 and 2923.17B of the Ohio Revised Code. Unlawful possession of dangerous ordnance is a felony of the 5th degree, and convicted or plead guilty to that, the court can impose a prison term and/or fine related to prison terms for a 5th degree felony or 6, 7, 8, 9, 10, 11, or 12 months. The maximum fine is $2,500, equivalent for costs and restitution as well. Upon your serving any prison term imposed on count 14, the law provides for an optional 3-year post-release control period when you're being released from prison if the parole board of the state finds that your release from prison on post-release control is necessary for you. Again, if you are released on post-release control pursuant to that count, the parole authority will supervise your conduct. Count 15 charges you as follows. It charges there that Angela Jo Wagner, on or about the 22nd day of April 2016 in the county of Pike and in the state of Ohio, did unlawfully, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any document or thing, to wit, phones and or cameras and or unidentified items belonging to the victims for the purpose to impair its value or availability as evidence in such a proceeding or investigation, in violation of section 2921.12A1 and 2921.12B of the Ohio Revised Code. That states tampering with evidence and is a felony of the 3rd degree. If you're convicted of it, plead guilty to a felony of the 3rd degree, you can be sentenced to serve a prison term and or pay a fine. The basic prison terms for a 3rd degree felony are 9, 12, 18, 24, 30, or 36 months. The maximum fine is $10,000 for costs and restitution. Upon your serving any prison term imposed on count 15, you may be released from prison for an optional period of 3 years if the parole board determines that you released from prison and post-release control is necessary for you. Count 16 charges a second count of tampering with evidence. It states that Angela Jo Wagner, on or about the 3rd day of April, or April 3, 2016, in the county of Pike and in the state of Ohio, did unlawfully, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, make, present, or use any record, document, or thing, to wit, custody documents, knowing it to be false and with purpose to mislead a public official who is or may be engaged in such proceeding or investigation, or with purpose to corrupt the outcome of any such proceeding or investigation in violation of section 2921.12A2 and 2921.12B of the Ohio Revised Code. Tampering with evidence is charged in count 16. Is also a felony of the 3rd degree, punishable by possible prison term and or fine if you're convicted or plead guilty. Possible prison terms of 9, 12, 18, 24, 30, 36 months. The maximum fine is $10,000 for restitution costs. Also, when you serve in the prison term on count 16, there's a possibility that you'll be released from prison on post-release control for an optional period of 3 years if the parole board of the state attorney that you post police control as necessary for you. Count 17 charges a third count of tampering with evidence and reads as follows. Angela Jo Wagner, on or about January 1, 2016 through May 9, 2017, at the County of Pike and in the state of Ohio, did unlawfully, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, altered, destroyed, concealed, or removed any record, document, or thing, to wit, silencer and or shell casings and or parts of a home security system and or other unidentified items with purpose to impair its value or availability as evidence in such a proceeding or investigation in violation of section 2921.12A1 and 2921.12B of the Ohio Revised Code. That states again, tampering with evidence, a third-degree felony, and is punishable by possible prison term and or fine. If you're convicted of plead guilty, the basic prison term is 9/12/1824, 30 for 36 months. The maximum fine is $10,000 for restitution of costs. When you're serving in the prison term imposed in count 17, you may be released from prison post-release control for an optional period of 3 years. Again, if you go over the state terms of post-release control is necessary for you. Count 18 charges you with forgery, 5th-degree felony, and reads as follows. Angela Jo Wagner, on or about April 3rd, 2016, in the County of Pike and in the state of Ohio, did unlawfully, with purpose to defraud, or knowing that the said Angela Jo Wagner was facilitating fraud, forge any writing, to wit, custody documents without the other person's authority, and or did forge any writing, to wit, custody documents so that it appears to be genuine when it is actually spurious, or to be the act of another who did not authorize that act, or to have been executed at a time and place or with terms different from what in fact is the case, or to be a copy of the original when no such original exists, in violation of section 2913.31A1 and or A2 and 2913.31C1B of the Ohio Revised Code. Forgery is a 5th-degree felony. If you're convicted of plead guilty to that charge, you can be sentenced to serve a prison term and or pay a fine. The basic prison term for 6, 7, 8, 9, 10, 11, or 12 months. The maximum fine is $2,500. Also have a court cost of restitution when you're serving in prison term imposed count 18. You may be released from prison on post-release control for an optional period of 3 years before the terms that you release from prison on post-release control is necessary for you. Count 19 charges you as follows. Angela Jo Wagner, on or about July 1, 2014 through May 9, 2017 in the County of Pike and in the state of Ohio, did unlawfully in any manner or by any means, including but not limited to computer hacking, did knowingly gain access to, attempt to gain access to, or cause access to be gained to any computer, computer system, computer network, cable service, cable system, telecommunications device, telecommunications service, or information service, to wit, media accounts, without the consent of or beyond the scope of the express or implied consent of the owner of the computer, computer system, computer network, cable service, cable system, telecommunications device, telecommunications service, or information service in violation of section 2913.04B and 2913.04G2 of the Ohio Revised Code. That states unauthorized use of property and is a felony of the 5th degree. Possible prison terms for a felony of the 5th degree are 6, 7, 8, 9, 10, 11, or 12 months. The maximum fine is $2,500. For also the cost of restitution when you're serving in prison term imposed in count 19. You may be released from prison for an optional period of post-release control of 3 years. If the court determines that release from prison for post-release control is necessary for you. Count 20 charges you with protecting wire, oral, or electronic communication. It reads that Angela Jo Wagner, on or about July 1, 2014 through May 9, 2017, at the County of Pike and in the state of Ohio, did unlawfully and purposely intercept, attempt to intercept, or procure another to intercept or attempt to intercept a wire, oral, or electronic communication in violation of section 2933.52A1 and 2933.52C of the Ohio Revised Code. Interception of wire, oral, or electronic communications is a felony of the fourth degree. A felony of the fourth degree is punishable by a possible prison term and fine, and/or fine. The basic prison terms for a fourth degree felony are 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 18 months. The maximum fine is $5,000. It also covers costs of restitution if applicable, and also only serving the prison term imposed for count 20, or on count 20, you could be released from prison for an option for 3 years of post-release control, so determines. Count 21 charges you with obstructing justice and reads as follows. Angela Jo Wagner, on or about the 22nd day of April 2016 through November 12, 2018, in the county of Pike and in the state of Ohio, did unlawfully with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another, to wit, Edward Jacob Wagner and/or George Washington Wagner III and/or George Washington Wagner IV, or a crime, or to assist another, to wit, Edward Jacob Wagner and/or George Washington Wagner III and/or George Washington Wagner IV, to benefit from the commission of the crime, to destroy or conceal physical evidence of the crime or act, or induce any person to withhold testimony or information, or to elude legal process, summoning the person to testify or supply evidence, and/or did communicate false information to any person and/or the crimes committed by the said Edward Jacob Wagner and/or George Washington Wagner III and/or George Washington Wagner IV are felonies in violation of section 2921.32A4 and/or A5 and 2921.32C3 of the Ohio Revised Code. That states obstructing justice is a felony of the fifth degree. Possible prison terms for a felony of the fourth degree are 6, 7, 8, 9, 10, 12 months. The maximum fine is $2,500, including the costs and applicable restitution. Only reserved for imposed on count 21. There's also the possibility that you would be released from prison on post-release control for an optional period of 3 years if the parole board determines that you're released from prison on post-release control is necessary for you. Count 22 charges you as follows. Angela Jo Wagner, on or about January 1, 2016 through November 12, 2018 at the county of Pike, or by some manner enumerated in section 2901.12 of the Ohio Revised Code, whereby proper venue is placed in the county of Pike and in the state of Ohio, did unlawfully while associated with an enterprise, to wit, a group of persons associated in fact, including but not limited to immediate family members of said Angela Jo Wagner, to wit, Edward Jacob Wagner and/or George Washington Wagner III and/or George Washington Wagner IV and/or Rita Jo Newcomb and/or John Doe and/or Frederica Carol Wagner and/or other unidentified and/or unknown individuals, did conduct or participate in, directly or indirectly, the affairs of the enterprise through a pattern of corrupt activity or the collection of an unlawful debt, to wit, engaging either individually or while being aided and abetted by members of the enterprise who facilitated the incidences of corrupt activity in conduct constituting the offenses, including but not limited to the following, to wit, aggravated murder in violation of section 2903.01A of the Ohio Revised Code and/or murder, a violation of section 2903.02A of the Ohio Revised Code and/or aggravated burglary, in violation of section 2911.11A1 and/or 2911.11A2 of the Ohio Revised Code and/or unlawful possession of a dangerous ordinance in violation of section 293.17A1 of the Ohio Revised Code and/or tampering in violation of section 291.12A1 and/or 291.12A2 of the Ohio Revised Code and/or obstructing justice in violation of section 2921.32A4 and A5 of the Ohio Revised Code to include, but not limited to, the acts alleged in this indictment in counts 1 through count 21, which are incorporated as a fully rewritten herein, and/or at least one of the incidents of corrupt activity is a felony of the first, second, or third degree, aggravated murder and/or murder in violation of section 2923.32A1 and/or 2923.32B1 of the Ohio Revised Code. That states engaging in a pattern of corrupt activity and is a first-degree felony. A first-degree felony is punishable if convicted or plead guilty by a possible prison term and/or fine. Basic prison terms for a first-degree felony are 3, 4, 5, 6, 7, 8, 9, 10, or 11 years. The maximum fine is $20,000. The court will also court costs and restitution. And upon serving any prison term imposed for engaging in a pattern of corrupt activity, the first-degree felony, there's a requirement that you be released from prison for a 5-year period of mandatory post-release control. There are 3 specifications charged with respect to count 22. Those specifications are identical to those specifications charged with respect to counts 10, 11, 12, and 13, and 13. And so I will sort of summarize those. But specification 1 to the 22nd count is a firearm specification referred to as a 1-year specification. That means that if you're convicted of in count 22 and of specification 1 to the 22nd count, in addition to any prison term imposed on count 4 of the charge in count 22, the court would be required to impose a 1-year mandatory prison term for specification 1, and a prison term would be served consecutive to prior to any prison term imposed for the underlying felony. Specification 2 is a 3-year firearm specification. If you're convicted of the specification in count 2, found guilty of that, the court would be required to impose a 3-year mandatory prison term to be served prior to and consecutively to any prison term imposed for the underlying felony charged in count 22. And specification 3 is a specification that alleges that the firearm is an automatic firearm or is equipped with a firearm muffler or suppressor. And if you're found guilty of that specification, then in addition to any prison term imposed for count 22, the underlying felony, the court will be required to impose a 6-year mandatory prison term to be served consecutively to and prior to any prison term imposed for the underlying felony in count 22.
Your Honor, may I take our approach, please?
Wagner, do you feel that you understand all of the elements involved in the offenses that it's indicated that you were pleading guilty to, as well as the possible penalties that may be imposed if you do end up pleading guilty to those offenses and to those specifications?
Yes, Your Honor, I do.
It's the court's understanding that for the purpose of advising the defendant here that the defense of the state have stipulated that these offenses and these specifications are not, they're not, they do not merge. In other words, that these are not allied offenses of similar import, and that there's a separate animus for each, so that the defendant may be convicted of and sentenced as to each of the offenses stated and as to each of the specifications. Is that correct?
Yes, Your Honor, the defense does stipulate that. Thank you.
That is correct, Your Honor. The state of Ohio stipulates as well.
And also, it's the court's understanding that for the purposes of advising and subsequently sentencing the defendant that the defense of the state has stipulated with respect to the claim, with respect to findings the court must make when ordering consecutive sentences, that being that the consecutive service is necessary to protect the public from future crime, to punish the offender, are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public, and that at least two multiple offenses were committed as part of one or more courses of conduct, and harm caused by two or more multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the offender's conduct. Is that a stipulation?
That is, Your Honor, specifically 29-29-14, C4, I believe, will stipulate that those findings are in fact accurate and are, I guess, necessarily and appropriately applied to the sentencing in this case. Thank you.
The state of Ohio stipulates as well, Your Honor.
Also, Ms. Wagner, if you enter a plea to count 9 of the indictment, you would, by virtue of, or by reason of entering that plea to count 9, or plea guilty to count 9, be classified as a violent offender under Ohio's law. And it's presumed that you shall be required to enroll in the violent offender database with respect to that offense. And that you would have all of the violent offender database duties with respect to that offense for a period of 10 years after you initially enroll in the database. The presumption is a rebuttable presumption, and you have the right to file a motion to rebut the presumption, asserting in your motion that you were not the principal offender in the commission of the offense that classifies you as a violent offender, and requesting that the court not require you to enroll in the violent offender database, and that you not have all the violent offender database duties with respect to that offense. That motion must be filed at or prior to the time of sentencing. If you file the motion, a hearing will be held, and you would have the burden of proving to the court by the preponderance of the evidence that you were not the principal offender in the commission of the offense that classifies you as a violent offender. If you satisfy that burden, and the court finds by preponderance of the evidence that you were not the principal offender, then the presumption is rebutted. In that case, the court will continue the hearing for the purpose of determining whether, notwithstanding the rebuttal of the presumption, you should be required to enroll in the violent offender database and have all violent offender database duties with respect to the offense that classifies you. In making that determination, the court would consider whether you have any convictions for any offense of violence prior to the offense an issue that classifies you as a violent offender, and whether those prior convictions, if any, indicate that you have a propensity for violence, the court would consider the result of a risk assessment of yourself conducted through the use of a single valid risk assessment to establish section 5120.114 of the revised code. The court would consider your degree of culpability or involvement in the offense at issue that classifies you as a violent offender. And the court would also consider the public interest and safety. If you do not file a motion to attempt to rebut the presumption, or if you do file a motion but do not succeed in rebutting the presumption, or if you file a motion and rebut the presumption that the court determines after considering the factors mentioned that notwithstanding the rebuttal of the presumption, you should be required to enroll in the violent offender database and should have all violent offender database duties with respect to the offense that classifies you as a violent offender, then the court shall issue an order specifying that you are required to enroll in the violent offender database and have all violent offender database duties with respect to the offense that classifies you as a violent offender. In that case, you will be required to enroll in the violent offender database personally within 10 days after sentencing, if you were not sentenced to serve a term of incarceration, or as I understand that term of incarceration is being recommended and has been agreed to, or within 10 days after your release from incarceration if you are sentenced to serve a prison term. And you would be required to comply with all the duties of the violent offender database for a period of 10 years after you initially enroll in the database. And you would be provided written notice of your duties to enroll and be required to sign a form stating that you have received and understand that notice. Now, a plea of guilty constitutes a complete admission of the defendant's guilt. If you enter a plea of guilty to the charges specified here, upon the court's acceptance of the plea of guilty, the court could then proceed immediately with judgment and with sentence. You understand that?
Yes, Your Honor.
Let me go over one thing with you while we're at this before I go further. I've explained to you the various possible penalties for the offenses that you are charged with. If you plead guilty to all of those offenses and the specifications, and this requires a little bit of math here, but the possibility then is then that you could be sentenced to serve a period of 66 years in prison plus 174 months, which is the equivalent of 14 and a half years, for a total of 80 and a half years, and that is before we consider the mandatory prison terms imposed for the specifications. The mandatory prison terms for the specifications, for the possible mandatory for all the charges that you have here, are 30 years. So 85 and a half years plus 30 years for 110 and 1/2 years imprisonment would be a possibility of 30 years being mandatory if you plead guilty or found guilty of all of the charges 9 through 22. Is that the council agree with that?
Yes, Your Honor.
And also, in addition to that, the court adds up the maximum fines. The total of the maximum fines is $165,000. I tell you that because those are the maximums the court required to the maximum fine. The state of Ohio has indicated that in exchange for your entering plea of guilty to certain of the charges that have been specified here, as well as certain of the specifications to those counts, which have been put on the record here, the state of Ohio will make certain recommendations to the court. The state will recommend that counts 1 through 8 and specifications thereto be dismissed as one of those, and I believe there were 2 other specifications as to count.
Specifications 1 and 2 to count 14.
Up to count 14 that would be dismissed. The state would also make recommendations concerning what sentence the court should impose for the offenses that you plead guilty to in the specification. Other than the promise of the prosecutor to make those recommendations to the court, has anyone promised you anything at all or threatened you in any way at all in order to induce you to withdraw your former pleas of not guilty and to enter pleas of guilty to the counts mentioned here earlier and the specifications mentioned earlier?
No, Your Honor.
If you do enter pleas of guilty to these various counts that's been placed on the record and specifications pursuant to this negotiated plea settlement, will each of those guilty pleas be voluntary?
Yes, Your Honor.
Now, if you do enter pleas of guilty to those counts and those specifications, the agreement that you have with the state of Ohio and the prosecutor's recommendations to the court with regard to sentencing are not binding upon the court. What that means is that in sentencing you on your pleas of guilty, if you enter those pleas, the court is permitted to disregard your agreement with the state of Ohio and to disregard the prosecutor's recommendations and to impose any penalties that the law provides for the offenses that you plead guilty to and for the specifications that you plead guilty to, notwithstanding any agreement that you may have to the contrary with the state of Ohio, notwithstanding any recommendations to the contrary that the prosecuting attorney may make. Do you understand all that?
Yes, Your Honor.
Has anyone promised you, and we've indicated here that some of these charges carry mandatory prison terms, has anyone promised you that if you enter pleas of guilty to the counts as specified, as put on the record here for the state, and to those specifications as put on the record here for the state, that the court will place you on community control centers?
No, Your Honor.
Has anyone promised you that if you enter pleas of guilty, as put on the record here, that the court will necessarily impose any particular sentence?
No, Your Honor.
You are, of course, a citizen of the United States.
Yes, Your Honor.
Before we went on the record today, here in the courtroom, did you have what you consider to be an adequate opportunity to discuss this case generally and this plea agreement specifically with your attorneys, Mr. Craig Pence and Mr. Hanna?
Yes, Your Honor.
And are you satisfied with the representation of these attorneys, with their advice and their counsel and their representation of your interests in this case?
Yes, Your Honor.
And Mr. Craig Pence and Mr. Hunt, have you informed the defendant of all possible defenses she may have, including any exculpatory evidence that might be brought to bear on her behalf?
Yes, Your Honor.
And the prosecutor over here has the state of Ohio furnished the defendant with all discoverable material and information, including any material and information that may be favorable to the defendant?
Yes, we have, Your Honor.
If you do enter pleas of guilty and the court imposes prison terms, I understand will be recommended and has been agreed upon by the defense. Upon your release from prison, as I indicated, for some of these counts, there's a mandatory period of post-release control for 5 years, and an optional period on other counts 3 years. Upon your serving any prison terms imposed by the court and being placed on community control sanctions, your conduct would be supervised by the Ohio Adult Parole Authority. If you then violate any of the terms and conditions of post-release control, notwithstanding the fact that you've served the prison terms imposed by the court of authority, the parole board could return you to prison. The rule is that the parole board could return you to prison for up to 9 months for each violation of post-release control. However, the total aggregate period for which you can be returned to prison by the parole board for all violations of post-release control cannot exceed 1/2 of the prison term imposed by the court. If you commit a new felony while you're on post-release control, there's another rule that applies. And that rule is that any court of the state that sentences you on any new felony committed by you while you're on post-release control right now in this case, that sentencing court, in addition to imposing a prison term for the new felony, may impose an additional prison term for the violation of post-release control. And the maximum period of additional prison term that may be imposed for the violation of post-release control is 1 year, or the time you have remaining in your post-release control period, whichever of those is greater, and any prison term imposed for the violation of post-release control control would be imposed consecutively to any prison term imposed for the new felony committed while you're on post-release control. Now, do you understand all of that?
Yes, Your Honor.
Understanding all of that, you still wish to enter a plea of guilty to the charges mentioned earlier in those specifications.
Yes, I do.
If you do enter a plea of guilty to the charges mentioned, and that counts 9 through 22, and to the specifications mentioned, by entering those pleas of guilty, you will be waiving some very important rights. These rights are protected you in the Constitution. So I want to go over these rights with you. I want to make sure that you understand your rights, and then I want to determine whether you want to waive your rights. So if you have any questions at all concerning your rights, please speak up and ask the questions, and the court will make sure that you do it with a better understanding before you indicate to the court whether or not you waive your rights. Your first right is the right to trial. You have the right to have each count of the indictment tried. In a case such as this, you have the right to trial by jury. If you exercise your right to trial by jury, that jury would consist of 12 persons, and all 12 jurors would have to agree on guilty before you can be convicted of any offense in the case. Now, if you waive your right to trial by jury, but you still want to have a trial in the case, you would have the right to have the trial before the trial. The judge sent without a jury, in which case the judge would have to find you guilty before you can be convicted of any offense in this case. And let me also say this, that the original indictment charged you also with capital crimes, the first 8 counts were capital crimes. If those crimes went to trial, it's a bifurcated proceeding. There's a trial phase, or sometimes there's a guilt phase, and then there's a sentencing phase or mitigation phase. And if you waive the right to that jury, you have the right to be tried before a 3-judge panel. But I'm advising you concerning your rights with respect to counts 9 through 22, because it's been indicated here that the state counts 1 through 8 are going to be dismissed. So, with respect to counts 9 through 22, you also have the right to trial by jury. It's not a bifurcated proceeding. And then, if you waive that right and you want to still have a trial, you have the right to have a trial for the trial judge. So without a jury, in that case, the judge would have to find you guilty before you can be convicted of any offense in the case. Now, you are presumed innocent of all the charges stated against you in this indictment. And on the plea of not guilty, that presumption of innocence continues throughout the trial, unless and until you are proven guilty beyond a reasonable doubt at that trial. On the plea of not guilty, the burden is on the state of Ohio to prove you guilty beyond a reasonable doubt at trial, and that means that on the plea of not guilty, the state of Ohio must prove each and every element of each and every offense stated against you in the indictment beyond a reasonable doubt at trial before you can be convicted and found guilty and sentenced on those particular charges. If this case went to trial on the plea of not guilty, whether it be a trial to a trial jury or a trial to a trial judge sitting without a jury, at the trial, you would have the right to face, confront, and cross-examine, or have your lawyers for you cross-examine all of the witnesses that the state of Ohio called to testify against you. You would have the right to subpoena and to compel the attendance of witnesses to testify on your behalf at trial, and you would have the right not to be forced to be a witness against yourself at trial. Now, if you enter a plea of guilty to counts 9 through 22, and to the specifications mentioned there, put on the record here, with respect to those counts and those specifications that you plead guilty to, you will be waiving all of the rights that I just mentioned. First of all, by pleading guilty, you will be waiving the right to trial completely, both to a jury trial and to the trial judge sitting without a jury. So there will be no trial at all if you plead guilty. You would be waiving the presumption of innocence if you were to plead guilty, because by pleading guilty, you're admitting to the court that you are guilty of the offenses that you plead guilty to and the specifications that you plead guilty to. And therefore, by pleading guilty, you would be waiving your right to require the state of Ohio to prove you guilty beyond a reasonable doubt before you can be found guilty, convicted, found guilty, and sentenced on the charges that you plead guilty to and the specifications that you plead guilty to. Now, because you would be waiving your right to trial completely by pleading guilty, And because there would be no trial at all if you do plead guilty, you would also, of course, by pleading guilty, be waiving your right to face, confront, and cross-examine. The orders for you cross-examine the witnesses the state of Ohio would have called to testify against you at a trial. By pleading guilty, you would be waiving your right to subpoena and to compel the attendance of witnesses to testify on behalf of the trial because there would be no trial at all if you plead guilty. And by pleading guilty, you would also be waiving your right not to be a witness against yourself because by pleading guilty and thereby admitting to the court that you are guilty of the counts, the offenses charged in these various counts, 9 through 22, and the specifications that have been placed on the record here, you are, in a sense, becoming a witness against yourself. Do you understand all of those rights and all of those waivers?
Yes, Your Honor, I do.
And do you want to enter into those waivers today and to relinquish and give up those rights and to plead guilty to counts 9 through 22 of the indictment and the specifications stated earlier?
Yes, Your Honor, I do.
If you do enter a plea of guilty to counts 9 through 22 of the specifications that we talked about here, and the court imposes upon you a maximum sentence, you have the right to appeal the maximum sentence. By pleading guilty, however, you would be waiving your right to appeal a finding by this court that you are guilty of the offenses and specifications that you plead guilty to, because again, by pleading guilty, you're admitting them to the court. And finally, by pleading guilty, you would be waiving a significant opportunity that you would otherwise have to take advantage of any mistakes that might have occurred at a trial in the case, which mistakes, if they did occur during the course of the trial, could cause a reversal of any conviction of yourself at that trial by the Court of Appeals. Do you understand all that?
Yes, Your Honor.
And understanding all that, you still wish to enter a plea of guilty in each of the counts 9 through 22, and a plea of guilty to all of the specifications, with the exception of the 2 specifications to count 14.
Yes, Your Honor, I do.
We had a sign.
I think I brought that to you, Your Honor.
I'm sorry.
I think I brought that to you right before we started.
Looks like it.
Did you sign this document entitled Plea of Guilty containing your agreement with the state of Ohio and the waivers that we talked about?
Yes, I did, Your Honor.
Did you understand this document?
Yes, I did.
Do you have any questions at all concerning this document, concerning anything that I've gone over with you on the record here today, or concerning anything at all about this case?
No, Your Honor, I don't.
Ms. Counsel, please satisfied.
We have to speak this.
We are, Your Honor. Thank you.
Please stand up. You have several, you've entered a not only plea to several things here, and we have to deal, we're going to deal in each case with the, do this count by count, specification by specification. Are you at this time withdrawing the formal plea of not guilty that you're given in count 9 of the indictment, wherein you are charged with conspiracy in violation of section 2923.01A1 and or A2 and 2923.01J1 of the Ohio Revised Code of Felony of the First Degree?
Yes, Your Honor.
And what plea do you wish to enter to the charge of conspiracy as charged in count 9?
I plead guilty.
And are you at this time withdrawing your formal plea of not guilty to count 10 of the indictment where you were charged with aggravated burglary in violation of section 2911.11A1 and or A2 and 2911.11B of the Ohio Revised Code, a first-degree felony?
Yes, Your Honor.
What plea do you wish to enter to aggravated burglary as charged in count 10?
I plead guilty.
You also have entered a not guilty plea to specification 1 as to the 10th count, which is a 1 year, which is a 1 year firing specification requiring the court to sentence you to serve 1 year in prison in addition to any underlying prison term imposed on count 10. And you've entered a not guilty plea to that specification. Are you withdrawing that not guilty plea to that specification?
Yes, Your Honor.
What plea do you wish to enter to specification 1 to the 10th count?
I plead guilty, Your Honor.
And specification 2 to the 10th count is the 3-year mandatory, 3-year firearm specification. requiring a 3-year mandatory prison term. Found guilty of that specification. Count 10, you previously pled not guilty to that. Are you withdrawing at this time your form plea of not guilty count? There's a specification to the 10th count.
Yes, Your Honor.
What plea do you wish to enter to
I
the
plead guilty, Your
specification?
Honor. I plead guilty, Your Honor.
And are you withdrawing your form plea of not guilty under the specification 3 to the 10th count, which is the 6-year mandatory? It carries a 6-year mandatory prison term. It gives the specification that states that the firearm is an automatic firearm or that was equipped with a firearm muffler or suppressor. Are you withdrawing the form plea of not guilty to that specification?
Yes, Your Honor.
What plea do you wish to enter specification 3 to the 10th count?
I plead guilty, Your Honor.
Count 11, charged with first degree felony aggravated burglary. Previously pled not guilty to count 11. Are you this time withdrawing your form plea to count 11, charging with aggravated burglary in violation of section 2911.A1 and or A2 and 2911.11B of the Ohio Revised Code?
Yes, Your Honor, I am.
What plea do you wish to enter to the charge of aggravated burglary, a first degree felony as charged in count 11?
I plead guilty, Your Honor.
And the specification 1 to the 11th count is that specification specified in section 2941.141 of the Revised Code, the 1-year firearm specification. Are you withdrawing your form plea of not guilty under the specification 1 to the 11th count?
Yes, Your Honor.
What plea do you wish to enter to specification 1 to the 11th count?
I plead guilty, Your Honor.
Specification 2 to the 11th count is the 3-year firearm specification requiring a 3-year mandatory prison term. If you found guilty or plead guilty to that, we previously read that, those specifications to you. Specification 2, you pled not guilty to that, and you're going not guilty to this time.
Yes, Your Honor.
What plea do you wish to specification 2 to the 11th count?
I plead guilty, Your Honor.
Specification 3 to the 11th count, again, refers to and charges a automatic firearm that was equipped with a firearm muzzle or suppressor, requiring a 6-year prison term mandatory. If you found guilty or plead guilty to that, previously pled not guilty or withdrawing, you're not guilty to plead count 3 of the 11th count.
Yes, Your Honor.
What plea do you wish to enter the count to specification 3 of the 11th count?
I plead guilty, Your Honor.
Count to 12 charges you with aggravated burglary, a first-degree felony in violation of section 2911.1181 and or A2 and 2911.11B. Ohio Revised Code, you previously pleaded not guilty to count 12. Are you withdrawing that not guilty plea this time?
Yes, Your Honor.
What plea do you wish to enter to aggravated burglary, that charge as charged in count 12?
I plead guilty, Your Honor.
And specification 1, the 1-year mandatory firearm specification charged with respect to count 12. You had previously entered a not guilty plea to specification 1 to 12 to 12 count. Are you withdrawing that plea at this time?
Yes, Your Honor.
And what plea do you wish to enter to specification 1 to 12 count?
I plead guilty, Your Honor.
Specification 2 to 12 count is the 3-year firearm specification requiring a 3-year mandatory prison term. If you found guilty or plead guilty to that, 2941.45 of the Revised Code section number, you previously entered a not guilty plea to that count, to that specification. Are you withdrawing your not guilty plea to specification 2 to the 12 count?
Yes, Your Honor.
What plea do you wish to enter in specification 2 to the 12 count?
I plead guilty, Your Honor.
And count 3 to the 12th count is 6-year muffler or suppressor specification. The firearm was an automatic firearm that was equipped with a firearm muffler or firearm suppressor. Previously pled guilty to specification 3 to the 12th count. Are you withdrawing that not guilty plea at this time?
Yes, Your Honor.
What plea do you wish to enter to specification 3 to the 12th count?
I plead guilty, Your Honor.
Count 13, charged with aggravated burglary, also in violation of section 2911.11A1 and/or A2 and 2911.11B, Revised Code, first-degree felony. You previously pled not guilty to count 13. Are you withdrawing that not guilty plea at this time?
Yes, Your Honor.
What plea do you wish to enter to count 13?
I plead guilty, Your Honor.
And we have the same three specifications. Count 1 being the specification under section 291.14 of the Revised Code requiring mandatory 1-year prison term. With that, you previously pled not guilty to that, or withdrawing your not guilty plea to specification 1 of the 13 count.
Yes, Your Honor.
What plea do you wish to enter to specification 1 of the 13 count?
I plead guilty, Your Honor.
Specification 2 of the 13th count is a 3-year firearm specification under 2941.45 of the Revised Code. You previously pled not guilty to count 2 of the 13th count, or count specification 2 of the 13th count. Are you withdrawing the not guilty plea that you previously entered to that specification?
Yes, Your Honor.
What plea do you wish to enter to specification 2 of the 13th count?
I plead guilty, Your Honor.
Specification 3 of the 13th count is charged under 2941.144 of the Revised Code, charging that the firearm was a automatic firearm, which is equivalent to the firearm muzzle or firearm suppressor. It carries a mandatory 6-year prison term. If you are convicted of guilty to that, you have previously pled not guilty to specification 3 of the 13th count, and you're withdrawing that not guilty plea.
Yes, Your Honor.
What plea do you wish to enter to specification 3 of the 13th count?
I plead guilty, Your Honor.
Count 14 charges you with unlawful possession of dangerous ordnance in violation of section 2923.17A1 and 2923.17D of the Revised Code. That's a second-degree felony. Are you withdrawing your previous plea of not guilty that you entered to the 14th count?
Yes, Your Honor.
What plea do you wish to enter to count 14?
I plead guilty, Your Honor.
Count 15 charges you with tampering with evidence in violation of section 2921.12A1 and 2921.12B of the Revised Code. Are you at this time withdrawing your formal plea of not guilty that you entered to count 15?
Yes, Your Honor.
What plea do you wish to enter to the charge of tampering with evidence as charged in count 15?
I plead guilty, Your Honor.
Count 16 charges you with tampering with evidence in violation of section 2921.12A2 and 2921.12B. Revised Code of third-degree felony. Are you withdrawing the formal plea of not guilty entered to the charge of tampering with evidence as charged in count 16?
Yes, Your Honor.
What plea do you wish to enter to the charge of tampering with evidence as charged in count 16?
I plead guilty, Your Honor.
Count 17 charges you with the third count of tampering with evidence in violation of section 2921.12A1 and 2921.12B of the Revised Code of third-degree felony. You previously pled not guilty to count 17. Are you withdrawing the formal plea of not guilty to count 17?
Yes, Your Honor.
What plea do you wish to enter to the charge of tampering with evidence as charged in count 17?
I plead guilty, Your Honor.
Count 18 charges you with forgery in violation of section 2913.31A1 and/or A2 and 2913.31C1B of the Ohio Revised Code. You previously pled not guilty to the charge of forgery as charged in count 18. Are you withdrawing that not guilty plea at this time?
Yes, Your Honor.
What plea do you wish to enter to the charge of forgery as charged in count 18?
I plead guilty, Your Honor.
Count 19 charges you with unauthorized use of property in violation of section 2913.04B and 2913.04G2 of the Ohio Revised Code of fifth-degree felony. Are you withdrawing the formal plea of not guilty that you entered to count 19?
Yes, Your Honor.
What plea do you wish to enter to the charge of unauthorized use of property as charged in count 19?
I plead guilty, Your Honor.
In count 20, you're charged with interception of wire, oral, or electronic communications, a fourth-degree felony, in violation of section 2933.52A1 and 2933.52C of the Ohio Revised Code. Are you withdrawing the formal plea of not guilty previously entered to the charge of interception of wire, oral, or electronic communications as charged in count 20?
Yes, Your Honor.
What plea do you wish to enter to the charge of not guilty to the charge of obstructing justice in violation of section 291.3284 and/or 85 and 291.32C3 of the Ohio Revised Code. Are you withdrawing at this time your former plea of not guilty to the charge of obstructing justice as charged in count 21?
Yes, Your Honor.
What plea you wish to enter into the charge of obstructing justice as charged in count 21? And in count 22, you're charged with engaging in a pattern of corrupt activity in violation of section 293.32A1 and 293.32B1 of the Ohio Revised Code, a felony of the first degree. You previously pled not guilty to that, or at this time withdrawing your former plea of not guilty, enter into the charge of engaging in a pattern of corrupt activity as charged in count 22.
Yes, Your Honor.
And what plea do you wish to enter to the charge of engaging in a pattern of corrupt activity as charged in count 22?
I plead guilty, Your Honor.
We have three specifications as to count 22. Specification 1 is a 1-year firearm specification requiring a 1-year mandatory prison term to be convicted of and plead guilty to that specification. You previously pled not guilty to that and withdrawing the former plea of not guilty to specification 1 to count 22.
Yes, Your Honor.
What plea do you wish to enter to specification 1 to count 22?
I plead guilty, Your Honor.
Specification 2, the 22nd count, is a 3-year firearm specification under 29.1.145 of the Revised Code. You previously pled not guilty to that. Are you withdrawing that plea at this time?
Yes, Your Honor.
What plea do you wish to enter to specification 2 to the 22nd count?
I plead guilty, Your Honor.
Finally, specification 3 to the 22nd count is a 6-year, carries a 6-year mandatory prison term if you're convicted of and plead guilty to that specification. That's a specification that alleges that the firearm is an automatic firearm or that was equipped with a firearm or suppressor. Are you withdrawing the former plea of not guilty to enter to specification 3 to the 22nd count?
Yes, Your Honor.
What plea do you wish to enter to specification 3 to the 22nd count?
I plead guilty, Your Honor.
Do we have statements of fact?
We do, Your Honor. Thank you, Your Honor. Your Honor, the charges in this case arise from events that first became known in the early morning hours of April 22nd of 2016. At that time, Pike County Dispatch received a 911 call from Dana Manley. She reported that she had made a very gruesome discovery, first at the house of Chris and Gary Rhoden at 4077 Union Hill Road, Piketon, Ohio, in Pike County, Ohio, and then subsequently at the home of Frankie Rhoden and Hanna Hazel Gilley at 41199 Union Hill Road, also in Piketon, also in Pike County, Ohio. All 4 of those individuals were found deceased, and it was later determined that they had died from multiple gunshot wounds. A short time later, more victims were found, specifically Dana Rhoden, Christopher Jr., also known as Little Chris, and Hanna May Rhoden were discovered in their home at 3122 Union Hill Road in Piketon, Ohio, Pike County, Ohio, also deceased from multiple gunshot wounds. Later in the day, an 8th and final victim, Kenneth Rhoden, was found in his home located at 1084 Left Fork Road in Reardon, Ohio, also in Pike County, Ohio. Pike County Sheriff's Office contacted the Bureau of Criminal Investigations to investigate, and it became apparent early on that whoever committed these crimes likely knew the family, and also that weapons with silencers had likely been used, as some of the victims had been killed in their sleep within close proximity of one another without waking. The investigation also showed that whoever committed the crimes removed the phones of most of the victims, along with trail cams and a DVR located at the victims' residences. Ultimately, the investigation led investigators to consider the Wagner family, specifically Edward Jake Wagner, George Wagner IV, and their parents, Angela Wagner and George Billy Wagner, as potential suspects. As the investigation progressed and pursuant to searches, investigators found shell casings at the Wagner's residence on Peterson Road that matched some of the shell casings that were left in the crime scenes. Investigators also found receipts and video evidence of the Wagners making purchases of shoes during the same month of the homicides that matched identically the shoe tread marks left in blood at one of the scenes, both in size and in style. Ultimately, agents interviewed the Wagners at the Canadian-U.S. border where more evidence was confiscated, including a laptop. Investigators also confiscated some of the defendants' phones and obtained and reviewed financial documents and accounts belonging to the Wagners. Investigators found that the Wagners were purchasing many items in preparation for these homicides in the 2 to 3 months leading up to the homicides. Items such as brass catchers, ammunition, magazines, clips, a phone jammer, a bug detector, and ultimately items for building silencers for different caliber guns. Investigators also found a screenshot from the laptop that was confiscated in Montana that revealed that the Wagners were, quote, hacking into the Facebook accounts of 2 individuals by accessing their accounts without permission. One of the screenshots taken revealed that there was a growing dispute between Jake Wagner and Hanna May Rhoden over their then 2-year-old daughter. Jake and Hanna had began dating when she was very young. She was only 13 years old. She conceived their daughter when she was age 15 and Jake was age 19. Jake and Hanna broke up just after their daughter turned 1, and eventually Hanna began seeing someone else and had become pregnant with that person's child in the summer of 2015. Jake was still interested in being with Hanna and would also get upset with Hanna over the fact that she was exposing their daughter to people that he did not like. In the meantime, Jake was pushing Hanna to go to court and sign documents regarding custody of their shared child. Hanna resisted that idea in December of 2015, sent a private Facebook message to another person telling that person that she would never sign papers ever. They will have to kill me first. That message was first seen by Angela Wagner, who took a screenshot of it and later showed it to Jake and the other family members. Angela Wagner saw that private message between Hanna and the other individual because the person Hanna was talking to happened to be one of the individuals of whom Angela Wagner had hacked into the Facebook pages of and was actively monitoring. 2 months later, investigators saw evidence of the Wagners beginning to prepare for these homicides, and 4 months after Hanna Rhoden sent that message, she and the 7 other members of her family were dead. Other evidence investigators found revealed that Jake, George, and Angela Wagner had executed custody documents that designated that Jake and Hanna's daughter would go to Jake should Hanna die. They also executed documents saying that Jake and Hanna's daughter and George's son would go to Angela, and Jake and George also met in early demise. These forms were printed off the Wagner computer on April 3rd of 2016, less than 3 weeks prior to the murders, but they were backdated to appear as if they had been executed 1 and 1.5 years prior to that. One of them bore the purported signature of Hanna Rhoden, and all of them bore what purported to be the notarization signature of Rita Newcomb, who is Angela Wagner's mother. Those documents were submitted to the lab at BCI, and they determined that Hanna May probably did not sign that form, and that the signature purporting to be Rita's also was probably not signed by her. Since that time, we have learned from Ms. Newcomb that she in fact did not sign or notarize those documents, and she believed that her daughter had, but was not present when any of the signings occurred. She also indicated that Angela Wagner had asked her to lie to the authorities and say that Rita had in fact notarized the 3 documents in question, when in fact Rita had not. Ultimately, Ms. Newcomb did not feel she could or should continue to lie to her daughter, and she sat down with us and told us the truth. We have now also learned that Hanna Rhoden also did not sign the form purported to be signed by her either, as the BCI lab had suspected, as Angela Wagner also forged Hanna's signature at the same time that she forged her mother's signature in the notary signature block. This was all done so that if anything happened on the night of the homicides, either harm or arrest of the co-defendants, that Angela Wagner would receive custody of the 2 minor children of Jake and George. Just before the indictment in this case in November 2018, investigators found the burn-up remains of the silencer for the Wagner's property at Peterson Road. It appeared to be a prototype that had failed. We have since learned that that is true. As this court knows, the state sat down with Jake Wagner in April of this year. Jake Wagner provided the state with many more details regarding these offenses, some of which were very consistent with what the state already knew and with the evidence that had already been collected. Some of the details were new and filled in the gaps of our information. In addition to the information that Jake provided us, he also led us to some evidence that had yet to be recovered, specifically the weapons and other items used in these offenses, along with the vehicles that were used during these offenses, including one that was bought specifically to use the night of the homicides only. The information that Jake provided clearly implicated he and each of the members of his family, to include Billy Wagner, Angela Wagner, and George Wagner, as being guilty of all the counts contained in the indictments filed in this matter. Jake Wagner spent 2 days providing us information and ultimately came into this court on April 22nd of 2021, 5 years to the day after the homicides, and admitted in open court that he was guilty of each and every one of the 23 counts contained in his indictment. As noted, the information he provided implicated each of his co-defendants and also being complicit in all of those offenses, again, as is consistent with our evidence. More recently, Your Honor, we sat down with the defendant present in court today, Angela Wagner, as she indicated that she would also like to do a proffer by providing us information about she and the others' involvements in these crimes. As this court knows, the state had purposely not provided a proffered statement of Jake Wagner to any of the co-defendants or their counsel, because the state wanted to ensure that if any other individuals elected to come forward, their statements would be pure, untainted, and uninfluenced by Jake's statements. In that way, the state could test the veracity of the statements of both Jake Wagner and any other individual that came forward. We just today provided a copy of the proffered statements of both Jake and Angela to Georgia's attorney, but until this afternoon, nobody else other than the state has been in possession of those. In her statement, Angela Wagner admitted that she and her family members, Jake Wagner, George Wagner, and Billy Wagner, all conspired together to commit these horrific offenses. Specifically, the entering into their homes in 4 different locations that we've already detailed and that are outlined in the indictment plea in order to kill the 8 victims in this case. Some were specific targets of the Wagners. Some, sadly, were killed simply because they happened to be there. After planning for months to commit these homicides and then carrying the homicides out, the 4 co-defendants spent their time trying to conceal any evidence of their crime, including asking others to either avoid the state or to be dishonest with us. Angela admitted to purchasing some items leading up to the offenses that were meant to help the other 3 co-defendants in carrying out the crimes, such as a phone jammer, which prevents people from being able to call for help, and the shoes that her 2 sons wore during the homicides, specifically of the size and style that they would not typically wear, and also to finding and printing off and forging the custody documents in question. She also admitted to being the one who would monitor the Facebook accounts of at least 2 individuals whose accounts they had acted to. She was fully aware of the plans and had discussed them at length with each of the other 3 co-defendants, both together and separately. She was aware the night they walked out of the door on April 21st of 2021 where they were going and what they were going to do, and she was present when they returned home the next morning, having completed the crimes. She had some conversations with them after the fact as well, confirming what they had done. As noted, they then tried to cover up their involvement, and Angela helped with those efforts as well. What the defendant provided to us in her statements were very consistent with what her son, Jake Wagner, had provided to us back in April of this year. Angela was also able to provide us with some additional details, including information about other crimes that her family has committed over the years. Based on the totality of the information now known by the state, including the statements of the defendant and her co-defendant, Jake Wagner, we have overwhelming evidence that the defendant and the 3 co-defendant members of her family are responsible for planning and carrying out the homicides of Chris Rhoden, Gary Rhoden, Frankie Rhoden, Hanna, Hazel, Gilley, Dana Rhoden, Hanna May Rhoden, Christopher Jr. Rhoden, and Kenneth Rhoden, which occurred on or about April 22nd, 2016, offenses to which the defendant admits to her and her family's involvement. Both Jake and Angela Wagner have admitted that in the late hours of April 21st into the early morning hours of April 22nd, 2016 is when they committed these murders. The defendant's 3 co-defendants trespassed into each of the 4 residences where the victims were found with the intent to kill them. They were armed with firearms, at least 2 of which had homemade silencers affixed to them, and they did so. The 4 co-defendants conspired together and planned these homicides for the months that led up to the offenses with full awareness of what the intended plan was, and all 4 co-defendants took part in that, as well as making various purchases to accomplish the goal. They removed the phones of all the victims and cameras and other surveillance equipment of the victims in order to avoid detection. Additionally, they destroyed those items along with trying to destroy and discard in a concealed manner the silenced prototype, along with all the other evidence in this case, including the weapons, ammunition, and other incriminating items. They forged documents to make them appear to be genuine, and they asked others to lie to cover up that particular crime. They hacked into these accounts of at least 2 individuals, allowing them access to information that ultimately became the motive for these crimes. The defendant engaged in a pattern of corrupt activity by acting as a part of criminal enterprise with the members of her immediate and some extended family members, while acting individually or while being aided and abetted by the other members of this criminal enterprise in committing the offenses of aggravated murder, aggravated burglary, and other offenses contained in the indictment. At this point, as noted, Your Honor, the defendant has in essence admitted to committing these offenses with her family members, and admits to personally assisting with the planning and preparations for these crimes, and either committing all of the offenses contained in the indictment directly or being complicit in the commission of them. As noted, she has also agreed to provide truthful testimony in the trial for co-defendants should she be called to do so. All of these offenses did occur in Pike County, Ohio, or in another county were committed as a part of the continuing course of conduct affiliated with the homicides that were ultimately committed in Pike County, Ohio, such that all of the counts in the indictment are properly brought into the jurisdiction of Pike County.
Thank you. Mr. Craig Anthony and Mr. Hunt, are there any amendments, corrections, or additions that you wish to make?
No, Your Honor. Thank you.
Ms. Wagner, are there any amendments, corrections, or additions that you wish to make to that statement?
No.
Did the special prosecuting attorney accurately and truly describe your conduct and behavior on the dates and times in question with respect to counts 9 through 22 and the specifications of each case?
Yes, Your Honor.
The court will accept you plea of guilty to each count 9 through 22, and will accept each plea will accept your plea of guilty to the specifications, 3 specifications as to counts 10, 11, 12, 13, you are guilty of those counts and those specifications. Is there anything further that we need to place on this record?
We have nothing further, Your Honor.
Anything further, please?
Not on behalf of Ms. Wagner. Thank you.
We are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
No, anytime we're good. Yeah, we're going to get that drop back. Just get that document, right? Oh, yeah, did have to say
We're just going to initial, correct? We do that.
that was the hard part. See what happens with the other one. I got a sleep suspension. It might not be quite as good. Oh, no. Just I'm clear. Shit. Oh.